On Module 1, we have the opportunity to explore governance, specifically how are post-secondary institutions governed. On Module 2, we're going to explore where did their authority come from. In the context of post-secondary institutions, authority is the ability to take particular actions and the potential legal liability for exercising this authority. Trustees, officers, administrators of post-secondary institutions, public or private, may take only those decisions they have authority to make. Acting or deciding without authority can have legal consequences not only for the individual, but also for the institution. To understand the limits and scope of authority is critical. Authority originates from fundamental legal sources that establish an institution. For public institutions, this will be the state constitution or state authorizing legislation. For private institutions, this will be the Articles of Incorporation in combination with state license. Other sources of law must also be considered, which also stems from court decisions. For public institutions, state administrative law and agency law. For private institutions, state corporations law, trust law, authority of post-secondary institutions are delegated to officers, employees, committees and boards, internal organizations, which includes faculty senate or student government. There are several ways this authority is delegated. Inside the institution, governing board bylaws, institutional rules and regulations, employment contracts, administrative rules and regulations of state education boards or agencies. Outside the institution, university research foundations, athletic clubs, and more. There are several types of authority. Express, which is the plain meaning of a written grant or authority. Implied, this can be inferred from express authority. And apparent, which is not an actual authority. It is the actual belief that authority exists when it actually does not. The doctrine of estoppel is relevant here. This is a liability for harm caused to persons who rely to their detriment on an appearance of authority. Liability is the consequence of the exercise of authority. In the context of post-secondary institutions, there are three types of liability that can be carried. It includes those in torts law, contracts law, and civil rights law. A tort claim involves a claim that the institution or its agents owed a duty to one or more individuals to behave according to a defined standard of care, that the duty was breached, and that the breach of the duty was the cause of the injury. The most common torts that can be found in post-secondary institutions are negligence and defamation. If the institution owed a duty to the injured party, the institution failed to exercise due care to avoid injury, and the failure was the proximate cause of the injury, this is negligence. The most common claims for injury in a post-secondary educational setting are injuries sustained on campus premises for lack of maintenance of campus grounds, educational malpractice in a classroom setting, and more. Defamation. In the context of post-secondary institutions, defamation is committed by the oral and written publication of information that tends to injure a person's reputation. This information must be communicated to a third person and must have been capable of defamatory meaning, and as understood as referring to the plaintiff in a defamatory case. Defamation claims are usually brought to officials of the institution, such as deans or department chairs. One example is a defamation claim based on what a faculty wrote on a letter of recommendation, which the plaintiff may have found to be very negative. Contract law. Institutions face potential breach of contract from employees, students, and vendors. The institution is considered the principal, while its administrators, trustees, and other employees are considered agents of the institution. The key to the institution's liability is authorization. The institution may be held liable if authorized the agent's action before it occurred, or if it subsequently authorized the action. The issue of authorization can be very complex, and you will be exploring that more in the case law as you go through your readings. Civil rights law. The tort and contracts liability of post-secondary institutions are based in state law and, for the most part, are really well settled. However, the institution's federal constitutional rights liability is primarily a matter of federal law, which has undergone a complex development. The key statute governing the enforcement of constitutional rights, commonly known as Section 1983, reads in pertinent part, every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other persons within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the constitutions and laws shall be liable to the party injured in any action at law, suit in equity, or other proper proceeding for redress.